care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option.
Okay. I disagree with you. All right. Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise for the court, please.
Oh, I'm sorry. What suggested language on the cert report?
I'm sorry, Judge.
Any suggested language on their question?
No, I think the court's correct that in terms of the cert report request, the court's answer is right on point, which is you are directed to concern you're directed to review the evidence that's in front of you, and that's it.
I'm just going to say you have all the evidence in this case. We will not give you anything. Okay.
Rise for the jury.
You see it?
All right, so jurors, we're in receipt of your question. Can we request the CERT report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor and has failed to prove all the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different, and we have to sort of change we have to indent something and change the spacing a little bit to make it a little bit clearer for you. Okay, so we'll get that into you in the next 10 minutes. All right, thank you all very much. Jim.
Court will be recessed.
All right, so the verdict slip will go into the jury. I instruct you or Officer Leiden to remove verdict slip for count number 2 from the jury, have the jurors fold it, put it in an envelope, and seal it. And we'll bring that in and we'll mark that for identification. I'm also going to send in a transcript of the supplemental instruction I gave this morning. May we mark that? Madam Court Reporter, please. I have copies for council if you'd like.
Yeah, sir.
Yes.
Thank you.
All right, so with that, we'll be in recess. And you'll remember that the jurors were instructed that we won't take any questions or verdict during 1 o'clock to 2 o'clock.
I missed that last one.
The jurors were instructed in the instructions I gave yesterday that we will not take a verdict or a question from 1 to 2. So everybody's free to go for
Thank
lunch.
you.
All rise for the court, please. Please rise for the jury. Please be seated for the session.
All right, jurors, you've been working hard today. I understand you want to go home, so we'll suspend for the day and we'll see you tomorrow morning ready to start right at 9. So please follow those same 3 instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Put the whole case out of your mind until tomorrow. We'll see you tomorrow.
All rise for the jury. Jury out, please. Turn around.
All right, we'll see you tomorrow. We're all set.
All rise, please. We'll be in recess.
Goodbye.
Hey there, Karen Reed, trial watchers. You know what a lot of the trials we cover remind me?
It's that you got to be careful who you surround yourself with, who you let into your life. Do you really know? I mean, it's a scary thing to think about. Well, that's why I'm so thrilled to talk to you about the sponsor of this week's Law and Crime Trial stream, truthfinder.com. Honestly, with our content, I really can't think of a better service that can provide actual safety for you guys. Why do I say that? I say that because Truthfinder is one of the largest public records search services in the United States. Their whole goal is to help people like you learn about the people in their lives. And here's how it works. You go on their website, truthfinder.com, and you type in a name. For instance, your new neighbor. Let's say your new neighbor is me, Jesse Weber. Make it easy. You type in my name, and within minutes and a paid subscription purchase, you can access unlimited reports that could include information like phone numbers, location history, criminal and traffic records, including possible arrests and criminal convictions. Goes without saying, but I don't have any of those. Truthfinder has been partnering with Law and Crime for a while now. We actually use it to research some of the cases that we've been covering. But in general, it can help provide peace of mind when you do these unlimited public records searches. Also, you know what's really useful? From within that report, you can search an address to see registered sex offenders that may live in that area too. That's the point. Unless you use Truthfinder, you may never know the reality about the people around you. Also, Truthfinder is just an incredible resource to use when reconnecting with people like long lost friends, family members you haven't spoken to in a while. You can use Truthfinder to help track down these people's information. It's just a great tool. Now, here's the kicker. Right now, you can get 50% off of your first month of confidential background reports. Just go to truthfinder.com/LC Live.
I think we only have about 2 weeks left of this. So whatever we're going to learn is going to come out within these next 2 weeks.
Are we going to hear voicemail messages from Karen Reed, Kevin?
Yeah, we are. And we got a long way to go. We got to get the Trooper the Trooper Garino will talk about all the data. We're going to hear the other data experts. We're also going to have the medical examiners. But most importantly, we got the CARS report that'll give the state's accident reconstruction theory. And we do need that.
And Nick, what do you think the defense is going to do in their case? And I don't expect Karen Reed to testify. They've got their own experts. Are there any other fact witnesses that the defense you would expect to bring in here to bring up a point, clarify something, or bring up some evidence that the prosecution has completely ignored?
So one quick thing, I think the defense is not going to even bother cross-examining the remainder of the witnesses that the prosecution calls. I think they are ready to put their case forward. And as far as what witnesses they have that they're going to call, we know they have the Fed experts that are going to confirm John wasn't hit by a vehicle and Karen's vehicle did not strike a body. You're going to have their Google experts come.
When there is no eyewitness to a murder, prosecutors need to get the evidence to speak to the jury. Physical evidence, DNA evidence, and digital evidence that can pinpoint movements and actions. In the case of accused killer Karen Reed, it seems like prosecutors will need all three to convince the panel of 12. I'm Vinnie Politan. Thanks for joining the investigation, and I'll see you weeknights at 8 p.m. Eastern on Closing Arguments. It was a trial unlike one we have ever seen. A college professor charged with murder that turned into something quite different. A case filled with public outcry, protests at the courthouse, allegations of witness intimidation, and an absolute storm of opinions all over social media. This is the case of Karen Reed, accused of purposely backing over her boyfriend, Boston police officer John O'Keefe, with her Lexus SUV and then leaving him to die in the snow. She's charged with murder, but she didn't just plead not guilty, she proclaimed her innocence on the courthouse steps. Then, hundreds of members of the public joined her cause, accusing police of framing Karen Reed for the murder that another member of law enforcement committed. Accusations of a cover-up and corruption, followed by a federal investigation of the state investigators. But now, all of the evidence is in, the lawyers have made their final arguments, and it's time to hear from the jury as we investigate the tragic death of Boston police officer John O'Keefe. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. A big, big day in Dedham, Massachusetts. This is it. We are officially in a verdict watch. Now, the jury is not deliberating at this moment, but any moment they're deliberating, the verdict can come. That's what you need to understand. That's what I understand. So when the jury comes back, anytime they're at that courthouse, be ready, folks, because it could happen and you don't want to miss it. Tonight, we're going to talk a lot about closing arguments here on Closing Arguments, because that's what you had. Both sides, after this long, long trial, had an opportunity, limited to an hour, to tie the case together, to bring in all those pieces from the beginning of the trial, the middle of the trial, the end of the trial, put them together and explain what happened, number one, and number two, make your arguments as to what it all means. This was it. This was a big, big moment for both sides. Now, as we sit here and wait, could take hours tomorrow, could take a few more days, could take us into next week. We don't know. But there's a couple questions. First, will John O'Keefe's family, will they get justice? And when you ask that question, and when I ask that question, will they get justice? To me, justice for the family of a victim is getting to the truth. When a jury says the word guilty, they have spoken. When a jury says not guilty, they haven't really spoken. What they've said is the person accused, it wasn't proven. So from my perspective, when a jury says not guilty, it's not because it's not guilty that they don't get justice, it's that they don't get the answer. Because the only people who can answer the question about what happened to John O'Keefe and who is responsible is the jury. So will they get justice? Karen Read, will she get justice? From her perspective, and what we've heard from her and attorneys from the beginning is that she's been framed. So it's obvious for her, the words not guilty mean justice for her. And you look at it, it's quite different than the family, the defendant. Obviously, they're in different positions and perspectives. But on one side, not guilty means justice. On the other side, guilty means justice because it's an answer. But if the jury says not guilty, the question still lingers about, is that the end of this? Is it over? Now, and all this will be decided by 12 people who didn't know each other before this case started. 12 strangers coming together and having to agree as to what happened and what exactly it means. What an incredibly awesome responsibility they have. That's how our system works. We have to believe in it because it is the best system. We know it's not perfect. The Innocence Project has taught us that it's not perfect, but it is the best system of justice anywhere. Let's bring in the best anywhere. Court TV crime and justice correspondent Matt Johnson, who is joining us live in Massachusetts, outside the courthouse in Dedham. The folks are lining up all ready to get into court tomorrow. Wow, what a big day, Matt. What a huge day. Let's start in the courtroom this morning. What was it like inside there?
Hey, Vinny, nice to see you. What a day indeed. It all comes down to this and very tense moments in that courtroom today, leading up to those closing arguments, these final pushes by these attorneys trying to sway these jurors to think about their details the most. Karen Read telling me that she feels good and very confident after day one of deliberations. She didn't make much eye contact to the people in the gallery that were facing the media. Again, we are right behind the O'Keefe family, and it was kind of a shock to many people, including the jurors, I noticed, because they recognized the people in the second row in that part of the gallery because it was the McCabe's and the Alberts, including it was Brian and Colin Albert, Jen McCabe, Carrie Roberts. They were in the gallery. And then also, of course, you had what you're looking at is Karen Read's family, William and Janet Read, along with her brother and her other supporters that have been there each and every day. But everyone hanging on every word today, Vinny. Quite the closing arguments in quite the close space in that very tiny courtroom.
That's the part that I don't know if it translates onto television, but it is such a small courtroom for such a big case. And you've got people who obviously have strong feelings about everything, and they're all next to each other, looking at each other, and then the jury's in the middle of it all. All right, let's get to the closing arguments from today. The last opportunity to persuade this jury one way or another. How'd that go?
Yeah, and each side only had 1 hour, and the judge kept them to it. We'll talk about that in a minute. But Alan Jackson was first. Commonwealth goes second in the state of Massachusetts. So right out the gate, he was holding back no punches in this case. And he was really doubling down on the defense theory that this is a cover-up, that Karen Read, the defendant, his client, is being framed. And here's what he told that jury.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. You have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. You see, you're the only thing standing between Karen Read and the tyranny of injustice. Sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. He got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. Karen Read is innocent. Do justice and find her not guilty.
As for the Commonwealth, ADA Adam Lally, he focused on key evidence in the case, including the taillight and also Karen Read's own statements to fellow witnesses, and I hit him, and also her text messages and her voicemails. Here's part of his closing.
I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant 4 times. There is no conspiracy. There is no cover-up. There is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. 2 things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional. There's no defense to them. And the defendant killed John O'Keefe.
And then something happened that we don't normally see here at Court TV in cases that we cover from coast to coast. Remember, the judge said you have exactly 1 hour. She gave them a 5-minute warning. And with 3 pages left that he was going to read, Adam Lally ran out of time. This was that awkward moment.
Ms. Hanley, in regards to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes, ma'am. The defendant drove her vehicle in reverse for 24.2 miles per hour for 62 and a half feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing his death.
Mr. Lally, I have to stop you. You've gone over. Okay?
I literally have 1 sentence.
1 sentence I'll give you.
From that facts and that evidence, I would submit and electively demonstrates her guilt on each of the indictments before you, and I would ask that you find it so. Thank you.
Jury members after that were looking at each other. They were looking over at the judge. I have to say that a lot of times during his closing argument, they were looking down. Now, during Alan Jackson's closing argument, they were looking at the defendant for mostly part of the time and then laser focused on Alan Jackson.
Yeah, what an incredible scene inside the courtroom with the arguments being made. Everyone is right there. And as these arguments are being made, the jury can see the people being accused of conspiring to kill and cover up what happened to John O'Keefe, sitting with John O'Keefe's family. You've got Alan Jackson making bold accusations across the aisle. You have a prosecutor running out of time. It's this whole thing for 9 weeks has been unlike any trial that I've covered in the history of Court TV for many different reasons. And today was very demonstrative of all of that. That's inside the courtroom. And that's only half of the story. Tell us about what was going on outside of the courtroom, outside of the courthouse today.
Right. So you have the media that is sleeping on the sidewalk. You see them lining up here behind me to get into the courthouse tomorrow. 200 feet away from here, you had nearly 400 supporters that were out in front of the courthouse cheering for this defendant, Karen Read. Pretty much a media circus, if you can imagine that as well, because there was media from coast to coast and also as far as Germany that are interested in following the case on Court TV UK. And here is the reception that Karen Read was greeted with and what she told us. Karen, your message for your supporters that are out here.
Thank you.
Oh, good.
Come on, let it go. Come on.
So in the course of us covering this trial from the very get-go, from those first pre-trial hearings at this courthouse, we've gone from dozens of supporters holding signs on the courthouse steps here in the snow, in freezing temperatures, to sweltering heat and hundreds of people here. So I asked them each and every time, what brings you here? What resonates with you? And being out here all day away from your family and your job, here's what some supporters told me.
We started out here for the pretrial hearings with 40, 50 people. Last count we had today was 450, which is amazing. Now we're sitting here waiting for the deliberations. A little nerve-wracking. The case resonates with people because any one of us could be Karen Read. I have 8 kids, 10 grandkids. Any one of them could be Karen Read. And with the corruption that's going on in part of the state, I wouldn't want that for my daughter or my son or myself.
And I believe even with this verdict, it's not going to give us true justice. I think it's going to clear and bring some truth, but then we need to fight for justice for John O'Keefe as well as Sandra Birchmore, because all the cases are linked.
And they're going to be out here until the end, until we have a verdict, Vinny. And as you know, they stand over by the church across the street from the courthouse. They hold up their devices, their laptops, their cell phones. They listen to courttv.com. They're waiting for a verdict to be rendered. And they really feel like the evidence is in their favor. As for the jury deciding the case back here tomorrow morning, Vinny, it is split in half, 6 men, 6 women on this jury that is now deliberating.
This scene is unreal. This is not a celebrity. This is not a politician. This is just someone who no one knew before any of this happened. And the way this whole story case has progressed, and I'm using this pun purposely, has really snowballed to this point where the number of people showing up at that courthouse waiting for this moment, this verdict, whenever it happens, it's going to be something else. Matt Johnson, live at the courthouse tonight. You've got a very long day tomorrow, Matt. You've got to get there early, and you've got to stay there all day, and then you've got to come back and join us at night. So Matt Johnson, Court TV Crime and Justice correspondent, thank you so much for your hard work. When we come back, we'll bring in our trial insiders. They're getting ready to go. Kevin Lenahan and Nick Rocco. We saw Nick there inside the courtroom this morning as well. What do they think of some of the evidence? That's coming up next, plus coming up next hour. We'll bring in our local think tank of high-powered Massachusetts criminal attorneys to tell us what they think about today's closings and what they think this Norfolk County jury will do.
This is an innocent woman. She didn't do it. It's a controversial case that's divided a community.
Karen Read is accused of murdering her police officer boyfriend.
Prosecutors say she ran him over on purpose and left him to die in the cold.
But Read claims that she's being framed.
It smells suspicious.
After years of legal fireworks, will the truth finally be revealed?
The end game is to figure out who killed John O'Keefe and hold these people responsible.
The Killer or Cover-Up Murder Trial. Live coverage weekday mornings, only on Court TV.
12/19/32. Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxson, and Ricky D'Antonio pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32, 34 Fairview Road, where his body is discovered the next morning.
The timeline. This case, the timeline is so important, and every single minute matters here. Absolutely matters. So there's Adam Lally going through 12:19 to 12:25. Let's listen to more of his putting together in his closing argument his version of the timeline.
Have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. The movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that 3-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, with 24.2 miles per hour for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event 8 minutes after the 3-point turn when the vehicle's in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at 1 Meadows Ave, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I hate you."
Let's talk more about this timeline with our insiders. Joining me tonight, Karen Read supporter, creator of the Justice for Officer John O'Keefe and Karen Read Facebook page, Inside the Courtroom Today, Nick Rocco, and the YouTuber behind Yellow Cottage Tales, Kevin Lenahan, is with us. Okay, so this is the prosecution timeline. Am I correct, Kevin, that he is alleging that the time of the fatal strike is 12:30?
Well, the time that John's phone last moves is 12:32. The time of the...
Oh, wait a minute. But didn't he just say that the car is thrown in reverse at 12:30? Right?
Yes. So what he does is he's calculating back from the 3-point turn that takes place at about 12:23, 12:24. 8 minutes later is when the next event is registered on there. Now, 12:32, the last time John moves, he's lying there, he's retching. So you can look back that maybe the actual strike took place about a minute before that. So you're not going to get it down right to the second, but you're matching up these various data pieces on the timeline. And to me, it's kind of bulletproof. So you got the 8 minutes coming from 3-point turn, which match the 3-point turn is shown on Waze and on GPS on John's phone. And then you got the health app data showing that he last moves at 12:32. But like I said, you can't say that we can't say for sure that we know that he's covered in throw up. So he probably was lying there unconscious and retching, and that probably maybe registered a little bit of movement for 30 seconds to a minute or something like that. But I think the timeline is pretty bulletproof.
Nick, your thoughts about the prosecution's timeline here and the most important time, like when did she actually do it? And today, the only way I can interpret his timeline and what he was saying is that it's at 12:30. I mean, I saw it on his timeline. We just showed it to everybody. That's the second triggering event, he calls it, when the car is thrown in reverse.
Right. Don't forget also, you have in his opening statement, he told you 12:45, right? So now it was 12:45, now it's 12:30. let's talk about the GPS for a second. So believe me, this GPS is accurate, okay? Even though two of my own witnesses, Nicholas Garino and Brian Albert, both told you that when they come into this area, the cell phone service is very shoddy. You barely get any service. But don't believe any of the experts. All but one person had said that all of these marks on John's arm and the gash to his head are not consistent with a pedestrian getting struck by a vehicle. Even Adam Lally's own medical examiner said that this is not a common injury to somebody who's been struck by a vehicle. But believe that the GPS data is accurate. You have Trooper Paul, who couldn't even tell us how this happened other than he got hit by the vehicle, he spun around, the phone landed underneath him, and that's how it happened. So believe him. And also believe this GPS data, even though nobody is consistent with that data.
Well, there's two timelines that were thrown in front of this jury today by both sides. So let's listen to Alan Jackson now talking about the timeline from the defense perspective.
But what's the real evidence of the unbiased data? The data that's not connected to the Albert family. How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monotonic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she'd left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie. And Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house.
Nick Rocco, I have a question for you on this. He's talking about a 3-minute offset, but what 3 minutes is being offset here? To me, that wasn't necessarily clear today in this part of his argument. Is he saying that 12:21 is actually 12:24, or is he saying that 12:19 is actually 12:22 on the prosecution timeline? What exactly is he talking about in a 3-minute offset? And how does is he saying that they're at the house at 12:21?
So what he's talking about is the Waze app. Basically, the clock that the Waze app takes from is 3 minutes behind the actual time in real life. So if the Waze app is showing 12:20, it's really 12:23. So that would align around I think it was 12:19 was the time Nicholas Garino said that it was registering stairs. But if you add those 3 minutes back, it's around 12:22. If he arrives around 12:21, goes in the house, it's about 12:22. He's going up and down those stairs. The 80 steps, I mean, when you drive in a car, it doesn't register as steps. Apple Health data is 98% accurate.
Let me ask both of you
was
this, because this is a big deal, right? You're both there. I presume you guys have phones. You may not have Apple phones. You may know someone with an Apple phone. Has anyone that you've known driven the route that the prosecution says was driven by John O'Keefe and registered these dips in the road as steps? I'll start with Kevin.
Yeah, and that I want to address the GPS first, Nick. GPS does not come from the cell phone towers. It comes from the satellite. There's a chip that's in your phone that comes from that. The strength of it you can measure in the signal strength, and that's part of the data that comes in. The signal became weak enough only for 4 seconds to include the accuracy becomes limited. This is the sensors in your phone. It's not just determined by elevation. My sister had this happen in the car last week, where she not there, but somewhere else, where it interpreted her as taking steps when they were driving. It has to do with the motion that your hand might be doing. That your hand might be doing too. There's a lot of things that go into this stuff. That clock is
But
very
ascending
accurate.
or
There's no way
descending, well,
that's 3 minutes.
but did anyone try this? Did anyone go on that street and try? Did you try it, Nick? Did anyone try it?
I didn't personally. Turtle Boy had done it the other day. He said that road was straight as an arrow. His phone didn't register any steps when he did it. So I'm not sure where Nicholas Garino was getting these hills from. Maybe he went a different route. I'm not sure, but the data. But if you look at the street, it's straight. It doesn't matter what the data says. Curves.
Interesting.
So what was he jumping up and down in his?
Turtle Boy is your source. Come on.
Okay. We're not going to get into that right now. Let's not get into that. I'm asking if anyone has done this. What I would have done, like if I was the prosecution, I would have done it. So, have an expert, hire an expert and go do it. That's kind of what they did in the Alec Murdaugh trial. They actually went out and did this stuff, the experts. Okay, let's listen to Ryan Nagel, because this is, again, I think an important witness when it comes to the timing, the timeline, and the arrival of John and Karen.
At any point, did you see that SUV in front of you drive up 50 or 60 feet, slam into reverse, and then drive backward?
No.
At any point, did you see that SUV reverse and hit a pedestrian?
Objection.
I'll allow that. You didn't see that, right?
No.
At no point did you see a person laying on the lawn?
No, but I also wasn't looking.
But you didn't see it.
No.
And you didn't see the truck in front of you.
The SUV, yes.
The SUV in front of you.
Correct.
All right. You didn't see a person standing or lying on the ground anywhere around that SUV, did you?
No.
But you did look inside.
Yes.
And you saw one person.
That's all I saw at the time, yes.
Female with long hair, is that
correct?
That SUV.
No, not to my acknowledgement.
All right, let me ask you this, Nick, because their arrival, is there a dispute about their arrival being 12:23 to 12:24? And if so, then Karen and John would have gotten there like 3 minutes before they did. I thought they were at the stop sign at the same time, and one car went first and the one went behind it.
Yeah, I mean, that's Ryan Nagel's testimony. Do we know how soon Karen pulled up before Ryan and his friends did? Could have been a couple seconds. It could have been a minute or two. I'm not 100% sure on that. But one interesting thing I did find today that Adam Lally said was, why was the dome light on? Well, the dome light comes on when someone opens the door, right? Well, that's not one. We know that's not the only way the light comes on. You can turn the light on yourself. But when you open the door, not only the light in the front seats turn on, but the lights in the back seat turn on. And sometimes when you have a big SUV, the lights in the trunk turn on as well. So it wouldn't have just been the driver's seat that was lit up. The whole vehicle of the inside would have been lit up if that door opened. The door didn't open. John was already in the house at that point. She had the light on. She was sitting there waiting for him.
What time did Nagel leave, Kevin? Because, Nagel doesn't see John O'Keefe in the car, but also doesn't see what prosecution said happened here. So what time is Nagel leaving?
Right. We don't know the exact time, but as you pointed out astutely, we do know what time he arrived because he texted his sister. So that shows that this whole clock thing is a bunch of nonsense. They arrived, both of them, at about 12:23/12:24. As far as what time he left, I think it's a reasonable thing to assume. You got to give his sister time to come out, talk to him for a minute outside, and go inside. So they probably left sometime between 12:25 and 12:31 when the accident happened, or 12:30. So they probably left around 12:27, 12:28, but we'll never know exactly down to the second.
All right, one more for you, Kevin. This bothers me a little bit. 12:30 is when she's alleged to have run him over. 36 steps on John O'Keefe's phone at 12:32. You just commit murder. I don't think you're going to hang there. I think you're going to leave. And we heard that it takes 6 minutes to get back to John O'Keefe's house from the scene. 12:30, if she leaves right at 12:30 after throwing the car in reverse and then pulls away, that gets her home at 12:36. What's going on 2 minutes later?
Oh, that was an Alan Jackson trick, and it was a beauty. The steps were from 12:24 to 12:32, and he just tries to suggest that they all happen at the end. Those 26 steps came within a large period arranged there. The GPS shows that John's phone, GPS is very, very accurate location device, and it shows that he never moved from that location where he was dropped off at the end of the property.
Okay, our insiders are staying with us. When we come back, let's talk about the tail light. When exactly was the tail light broken?
Take a look at this photograph and tell me, which one looks like Officer Barros's description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so.
Alan Jackson bringing up a huge point in this case, which is when exactly was that taillight broken? When did those pieces? Different versions going on here. Obviously, prosecutors say it's when Karen Reed's SUV struck John O'Keefe. The defectant to John O'Keefe's Chevy the following morning, but the rest of the pieces came off when Trooper Proctor took them off and then planted them at the scene of the crime. So, police, but here's video of the car being seized and towed in Dighton is the name of the town, Massachusetts. That's where Barros works. Take a listen now to Sergeant Nicholas Barros describe what he says the taillight looked like when the car was seized from Karen Reed's parents' driveway.
At some point, did you make any observations of the right rear part of that Lexus SUV?
I did.
And what, if anything, did you observe about that area of the vehicle?
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged.
Piece was missing, which is that reconstruction that Alan Jackson put together. He believes that's consistent with what Officer or Sergeant Barrows saw. Take a listen now to Adam Lally address this same issue of what Sergeant Nicholas Barrows actually saw when he sees the car.
The vehicle looked like that on the left when it was caked in snow, when Officer Barrows saw it in the driveway in Dayton as they were wading through 1.5 feet of snow, walking up, because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like.
Okay, so the picture on the left there is from the morning when you have police doing a wellness check on the kids who are home alone at that point, right? And that's from the dash cam or body, I think it's a dash cam, not the body cam. And if you look at the picture on the left, this is 8:23 in the morning, right? This is before Proctor is even on the case, for goodness sake. So look at the tail light on the right side of the car on the left side picture. Does that tail light look like the same level of damage as the tail light in Exhibit 145? Are they the same? Obviously, there's snow on Exhibit 102, but if you look at 102, the left tail light, you can see red all the way around. But on Exhibit 102, you don't see red all the way around on the right side. So what does this mean? Nick Rocco, tell me why Exhibit 102 does not look like Exhibit 145, the right tail light.
Well, like you stated, I mean, just look at the left tail light, for example. You can see a lot of red is missing due to the fact of snow being on it. So you have to assume that the right side that's broken has snow on it as well, the same way that basically what it's doing on the left side to the right side is covering up some of that snow, the tail light. So it's hard to compare in a sense of the left photo to the right photo, because the right photo is a clear picture of the tail light versus the left. But what you can't see in that dash cam video is the whole right side of her tail light that you see when she leaves the driveway at 5:07. You can't debunk the fact that the taillight is still intact at 5:07. You see it in the video. There's red plastic.
We'll get to that one. I'll show you that one. I'm showing both sides here. I want to start with this first photo, though. I want to take a look at Lally's. We can put it back up for Kevin. Kevin, you look at that photo. What are you seeing in the photo on 102 versus 145?
I don't think Nick wants to believe his lying eyes. You can see on the left that the red is there, and on the right, it's missing exactly where it's shown later in the Sally report. And also just want to remind people that at 5:30, Karen showed Kerry Robertson Jen, and Kerry testified that it looked exactly like we see later in the garage, and the defense chose not to cross her. They accepted her testimony. The taillight was in pieces.
Okay, now let's get to Alan Jackson and his closing argument and what he brought up about the status of the taillight.
Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished when Dayton Police Officer Barrows walked into this courtroom.
All right, Kevin, I'm looking at that photo, and I'm sure we'll get it up in just a second. But I'm looking at those pictures, and you look at the one, the top looking down, top left, I see some red on the side. I thought all the red on the side was gone.
Right, look at that picture right there. Look at the top part of that photo. People are focused on the bottom of it. Look at the top part, and you can see where the white light is coming out, and the large pieces are missing, exactly like it looks like later in the Sally part. And I have another video where I've zoomed in on that.
But the red piece on the side, does the red piece on the side exist in the Sally port?
It's exactly like it looks there. But one thing we have to keep in mind when it comes to ring systems, they use a system called night vision, and it adds color because it's infrared does not record in color. So these aren't going to be perfect. But if you look at the top picture there, you can see that piece missing in exactly the shape that's missing later on.
Nick, what are you seeing
perfect
there?
match.
What are you seeing? I know you're chomping at the bit here.
Well, when she first backs out of the driveway, it's indisputable that she hit John's car. I know Adam Lally's still saying that she came close to it, but we saw the tire move. Whether snow fell off the car or not, she hit the car. As far as the night vision, Kevin, you see when she backs out of that driveway, the floodlight turns on that camera. So it's more of a light that shines down. But I'll ask you the same question, Kevin. Do you not believe your lying eyes in this situation where I am looking at red taillight on the right side of her vehicle? There's no disputing it at this point because you can see it right there.
Look at the top.
There's nothing else to say other than if you
We
can't
are out
see
of
red
time
taillight
tonight,
there,
gentlemen. We're out of time
you gotta get
tonight.
glasses.
I've got to cut you off like the judge cut off Adam Lally. We're out of time, but thank you, Nick Rocco, Kevin Lanahan. We'll see you again tomorrow night as the jury watch continues. Okay, folks, when we come back, we will reveal something else you need to know tonight. On the next episode of Accomplice to Murder.
It looked like Virginia and Norman really had a wonderful relationship.
But then greed planted the seeds of a brutal murder.
$1.1 million in benefits to Virginia.
And when she couldn't find a hitman, she decided to use her son, Jason.
She said, no one is going to be getting in the way of me collecting that insurance money, or they'll wind up just like Norm.
Accomplice to Murder with Vinnie Politan. All new episode, Sunday night, 8/7 Central.
Only on Court TV. Welcome back. Time to reveal something else you need to know tonight. Let's take a look at our big board, and there you have him, Wade Wilson, the man with the tattooed face. Verdict today in the penalty phase of his trial. Let's take a listen.
We, the jury, unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Wade Wilson should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 9-3 that Wade Wilson should be sentenced to death.
9-3 for death on one count, 10-2 for death on the second count. He's off to death row. The final sentencing by the judge will be on July 23rd. So justice for the victims in that case. Wade Wilson heading off to death row in Florida. When we come back, folks, much, much more on the big day in Dedham, Massachusetts. We're going to bring in our high-powered criminal attorneys from up in Massachusetts. What do they think of all this madness? Boston police officer John O'Keefe was found lifeless in the snow on the front yard of another Boston police officer's home. But that home was never searched by police. In fact, no one who was inside the home the night John O'Keefe died was ever considered a suspect. The only suspect was the woman who was arrested and charged with Officer O'Keefe's murder, his own girlfriend, Karen Reed. She's been charged with purposely running over John in an alcohol-fueled rage of jealousy after an argument in her car. But Karen says she is factually innocent and John was murdered by someone in that house. All the evidence is in and the arguments have been made, and it's time to hear from the jury as we continue to investigate the tragic death of Officer John O'Keefe. I'm Vinnie Politan. Great to have you with us here on Closing Arguments. Big day in Dedham, Massachusetts. Big day. We've been covering this case for some time. Karen Reed back inside the courtroom today. Think about this. Opening statements in this trial were April 29th. That's almost 2 months ago. We've heard testimony from 74 witnesses over the course of 31 days of court. This was a big one. This was a marathon. This is a huge case with a lot of issues, a lot of evidence. And at the end of the evidence, you know what happens. It's the name of the show. Closing arguments happen. Now, in some cases we cover here on Court TV, the evidence speaks for itself. But in this case, all the evidence from both sides has been put in question. So that's why closing arguments, from my perspective in this trial, incredibly important. An opportunity to marshal the evidence, put it together so the jury can understand it, put it together so the jury can trust what you are trying to prove to them from both sides. Whether you're trying to raise that reasonable doubt based on some conspiracy, or you're trying to prove something beyond any and all reasonable doubt in a case where you have a lot of unusual circumstances and issues. So let's do this. Let me take you, if you didn't have an opportunity to see it, let me take you inside the courtroom so you can see the biggest moments from the closing arguments from the defense and the prosecution.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. And to add to that deceit, she was also blatantly lying about the calls to John's phone. She said that every single one of those calls to John's phone during that time was a butt dial. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. And that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. And my question to you is, what will you do with this moment? Ignore the lies, the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Read is innocent. Do justice and find her not guilty.
I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant. You heard testimony from Officer Saraf, statements that he attributed to the defendant as saying that morning. This is all my fault. This is all my fault. I did this. This is what the defendant is saying on scene. Since then, stories changed. In the darkness, in the snow, in the blizzard, in those conditions, the defendant sitting in the back seat of the vehicle knows exactly where Mr. O'Keefe is. But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance. The magic hair, as Mr. Jackson likes to call it. So the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left. What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence.
One sentence I'll give you.
From that facts and that evidence, I would submit and electively demonstrate her guilt on each of the indictments before you, and I would ask that you find us. Thank you.
Big day. I want to show you the verdict form. This is important because this is what the jury has to fill out in the jury room. This is how they make the decision. This is how they get to a verdict. So you take a look at what the choices are. Offense 1, murder in the second degree, not guilty, or guilty of the offenses charged. That's murder in the second degree. Second one, offense number 2, manslaughter while operating a motor vehicle under the influence, not guilty or guilty of the offense as charged, or guilty of a lesser included offense of involuntary manslaughter, or guilty of a lesser included charge of motor vehicle homicide. And finally, offense number 3, leaving the scene of an accident, not guilty or guilty of the offense as charged. Let's bring in our special local think tank, 3 attorneys joining us from Massachusetts tonight. You've seen them talk about cases on Court TV, and you've seen them win cases on Court TV. With us, criminal defense attorney Joseph Krowski Jr., also joining us, criminal defense attorney, college instructor, author Peter Ellikin, and attorney Rick Grundy. There you go. I gave you a nickname. Beautiful. Okay, let's talk about these closing arguments. Joseph, first, your thoughts about the 2 themes here. Don't look the other way versus I did it.
Sure. Well, first of all, Johnny Cochran never read a closing argument, did he? Maybe it's the old school in me. They both write well. They both can read what they wrote. But I think to really sell it and to own it and to feel it and to know your case, you put your notes aside, you go there and you talk to the jury for an hour. No real surprises here. I think if people are going to be objective, Adam Lally probably exceeded expectations given to some of the things that have transpired over the last couple of weeks. He probably was the more methodical one and stuck to what he believes the evidence showed. And certainly Alan Jackson never once for the theatrical and stuck with the conspiracy theory and interwove, he is from LA, the movie theme, corruption into it. So I wasn't surprised, and I don't know if it really moved the needle for either side. But again, the parties aren't situated similarly. Karen Reed's presumed innocent.
Peter Ellikin, what were your thoughts today? I mean, you're taking, we started this thing at the end of April, and this is the last opportunity. What happened?
Yeah, it's almost arrogant, I think, to do a closing argument because basically the jury heard everything you heard and now you're telling them what they heard. But if you do a good job, you really help put them in perspective and you're telling a story. And I thought that was rather effective on both their parts, that you are basically a storyteller and you're trying to show some passion and you're also just trying to, in this case, I almost felt bad because normally we don't like to use notes. As Joe just said, you like to just talk right off the top of your head. But I've never seen such a case that had so much minutia and fact specific. And you almost had to look down in your notes a little bit just to make sure that you hit every point and concise and do it in an hour. So,
or a little more than an hour in the case of Adam Lally. Before we run out of time here, and I got to cut you off like the judge, Rick Grundy, your thoughts about what we saw inside that courtroom today?
I would have liked to seen a little more passion come out of the prosecution. I think you start off by saying, make no mistake about it, ladies and gentlemen, this case is about one person and one person only. They're not in the courtroom with us today. That's John O'Keefe. John O'Keefe deserves justice in this case. And I thought I probably would have taken a walk over to that bar and said those words right in front of his parents and his brother, his sister-in-law, and tried to focus the jury in on the passion that's there, that the defense has been living off of, whether it's out in front of the courthouse or in presenting their case towards Karen Reed.
Okay, we've got this panel together tonight. When we come back, I want to go through some of the big pieces of evidence and ask each one how important it is and what it'll mean. We'll be back.
Action was just to pull out the revolver, and it went off.
Two people accidentally shot.
Alec Baldwin was the actor on set. Alec Baldwin? Yes, sir.
Hurry, hurry, hurry was the motto on the set.
Right away, let's reload.
Alec Baldwin claims he didn't pull the trigger. Well, the FBI disagrees.
It's not going to fire until you pull the trigger.
They really do have to show that he couldn't care less.
The Case Against Alec Baldwin premieres Sunday, 9/8 Central on Court TV.
All right, there they are. Alan Jackson, David Yannetti, and of course, Adam Lally on the right. We're going to go through some of the evidence right now with our special local think tank, Joseph Kraske Jr., Peter Ellikin, and Rick Grundy. It's going to be a rapid fire look at some of the biggest pieces of evidence in this case. What I want you guys to do, I'm going to go through a piece of evidence, 0 to 10, how important it is, and then tell us why. First one, Karen Reed's alleged confession. Let's take a listen.
She kept saying, this is all my fault. This is my fault. I did this.
What happened? And there was one individual that replied several times, I hit him. I hit him.
3 times. I hit him. I hit him. I hit him. Earlier, it was could I, did I? When she spoke to the paramedic, it was crystal clear. I hit him.
Joseph, 0 to 10.
8. Confessions, admissions of a defendant are always some of the most compelling evidence a prosecutor has. I'll couch that, though, that these confessions did not come in completely cleanly.
Peter.
I would also say 8. It was the strongest thing that the prosecution had, but then it was confusing. She started out saying, could I have hit him? Did I hit him? And then it sort of evolved and different people had different things to say about it. So it didn't absolutely nail and seal the deal with a confession.
Rick.
10. They've hung their hat on it. How much stronger would it have been if they had heard the newsreel where her father says 2 hours after the body was found, she told him, I was backing up, I struck something, I don't know what it was.
Next big piece of evidence, the so-called 2:27 in the morning search by Jennifer McCabe. How's long to die in the cold? Let's take a listen.
Do you have an opinion as to the timing of that first search for how long to die in cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
Okay, I'll start at the bottom. Rick, how big was this one, 0 to 10?
5. It depends on what their leanings are. If they're leaning one way, they're going to go with that expert. If they're leaning the other way, they'll go with the other expert.
Peter.
This could have been an 11 if we had to come up with an absolute definitive, definite, conclusive answer. But instead, we have the two experts, kind of canceling each other out. So if the jury walks away confused, that's not beyond a reasonable doubt. So it helps the defense.
You did not give me a number. I'm going to give you a 5 on that. Joseph.
I'll give it a 6 for the prosecution because that was really one of the original building blocks of the conspiracy theory. I'll give a 100 for Jen McCabe because she went from condemnation to vindication. I took all 3 experts to say that search more likely took place at 6 a.m. or 6:23 a.m. In the defense's own expert seemingly apologized for his wrong interpretation of the data.
Next piece of evidence, the voicemail left by Karen Reed after she allegedly murdered John O'Keefe, according to prosecutors. Let's take a listen.
John, I'm telling you, he is. Nobody knows what the he wants. Her. Yes, 1 in the morning, I'm with your niece and nephew. You her. You're John, I'm going home. I cannot leave you sitting me. I need to go home. You have you bitch right now. Another girl, he's sleeping next to me. You're a loser. So.
Peter, 0 to 10.
This is a 10 for the defense because I don't know why the prosecution was making such a big deal about this. She clearly didn't know he was dead. She kept making call after call and getting more and more upset. And where are you? And she's angry and the kids are left alone and all that. It would seem to show that she was not aware that he had died or that she hit him.
Rick.
I'm going to give it a 6 for the prosecution because even though I agree with Peter, I think it could help them with respect to if they get to a lesser included there, just as to her attitude and her drunkenness.
Joseph.
8 for the Commonwealth. That first call came in at 12:37. That's the most contemporaneous example of her state of mind 4 or 5 minutes after John O'Keefe was most likely struck by the car. It also shows her to be someone that is really easily triggered. I believe there was 53 phone calls she made to John O'Keefe. Interestingly enough, woven into those calls were 2 calls to her father at 1 o'clock in the morning and 4:30 in the morning. Usually don't call your father if you think you're being cheated on when you're in your 40s. You call your father if you think you did something, you're in trouble.
All right, let's get to one more big piece of evidence in this case, and this involves Trooper Proctor, the lead investigator, and the nasty text messages that he was sending to his superiors and some to his high school buddies.
Your assessment, personal assessment, that Karen Reed had struck this officer with a car, gave you license to call her a
It was my emotions that got in the best of me.
and you called her a whack job. Gave you license to call her that too.
Yes.
Gave you license to say to your friends, oh, no. She's right?
That's what I wrote.
Gave you license to say that she's a
Again, another disgusting comment.
You get to talk about her leaky balloon knot, right?
Objection. All right, Joseph, 0 to 10 on this.
I think that certainly is a 7 for the defense, although it might not bolster the suggestion of a conspiracy. Police officers, state police officers, the lead investigator, they have to be held to a higher standard. It's interesting they were able to get access to the phone, but certainly the optics are bad, and that might play a role in jury nullification.
Peter.
10 for the defense. And I'm going beyond just the sexist, repugnant comments that he makes and making fun of her multiple sclerosis and all that. The most important thing was he revealed what a shoddy, biased investigation he had. In those text messages, he said, I'm not going to even investigate anybody else, search the house, anything like that, because it's a Boston police officer. That was even more important than the horrendous, horrible statements he was making.
Rick.
When they get to the part where they say, look, this isn't 2 stories, pick one, the burden, that heavy burden is on the prosecution, agree with Peter, it's a 10, particularly in the light of the fact that he appeared unscathed by his employers or the district attorney's office for these actions.
Okay, so this is what I want to do right now. We are going to play for you the scene outside of the courthouse, the madness in downtown Dedham today after court while they're waiting for this verdict. And as we're watching it, I want to ask you what you think about this scene. And Joseph, I'll begin with you. What do you think about the scene outside of the courthouse?
I think it's an absolute circus. I just can't really comprehend the idolization in this case. Look, it's like nothing I've ever seen. It certainly, I think, is an outlier, but I don't think that they're dealing with this case with the solemnity that a murder case deserves. There are people literally tailgating during a murder trial. So, look, I get it. I know Jackson likes it. I know he plays to it. I know it's his thing, and it certainly seems to be helping him. And I'm sure it's probably invading the overall collective thought process of that jury. But I think it lacks a certain amount of decorum.
Peter.
This is so unprecedented. Normally when we see mobs outside of a courthouse, it's because they hate the guts of the person being accused. And the fact that there is such passion and the majority of people, it's not 50-50, it's probably 85% of the people in Massachusetts are on her side. I think it's because this one really has a lot of facts in her favor. It's not your standard open and shut, definite, she obviously did it.
Rick, I'll give you the final word on the madness in downtown Dedham.
2 quick things. The judge should have cracked down on Jackson trying his case on the sidewalk every morning and letting the defendant testify on the sidewalk in the morning. Secondly, I've been wanting to say this throughout this whole trial, but I question whether the prosecution should have backed away from Turtle Boy completely and agreed to do that, because you may wanted to have let this jury know that this conspiracy theory gained its traction through a guy hiding behind his keyboard who's a bit of a nutcase who is answerable.
We're out of time.
to
I
no
got to
one.
give you the Lally treatment tonight. Thanks, guys. Joseph Krowski, Peter Elkin, Rick Grundy. Up next.
Yes.
One more matter of housekeeping. I have another
In the high-profile Karen Reed murder trial, let's listen in.
All right, Mr. Jackson.
Thank you, Your Honor. Good morning, Officer Sheriff. Good morning. Is there anything that you would like to change or amend or modify about your testimony yesterday that you thought about overnight?
No.
Did you discuss your testimony with any person between the time you got off the stand yesterday and coming back?